and Europe, and good morning, afternoon to everyone joining us from the US. I would like to first extend a warm welcome to our special guests, former President of the Israeli Supreme Court, Justice Aharon Barak, and our moderator today, Professor Gabriella Blum from Harvard Law School. Thank you for joining us.
Thank you.
I'm Yaniv Bejarano, and I'm part of a group of organizers in Boston who stand with solidarity with the protest movement in Israel and are working to make Israeli Americans and Jewish Americans' voice heard through demonstrations and advocacy work geared at making Israel a vibrant democracy, a better place for all its inhabitants for generations to come. We are all honored and delighted to have former President of the Israeli Supreme Court, Justice Aharon Barak, with us today at the most critical time, on the very day that one of the main elements of the regime overhaul is back on the table, Ilat Asvirut, or reasonableness principle, which was part of the original so-called judicial reform package. In a minute, I will hand over the microphone to the moderator of the session, Professor Gabriella Blum, who will introduce Justice Barak and invite him to speak for approximately 20 minutes. The talk will be followed by approximately half an hour of questions posed by the moderator to Justice Barak. At 1 p.m. Eastern, some of you will have a chance to unmute your microphone and ask the Justice very short questions directly after raising an electronic hand and being called on. During the first hour, we will be muting all lines, but you can use the chat for questions and remarks that we will do our best to incorporate into the discussion. Please note this session is recorded. And now, without further ado, let me introduce our moderator. Professor Gabriella Blum is the Rita E. Hauser Professor of Human Rights and Humanitarian Law and the Vice Dean for the Graduate Program in International Legal Studies at Harvard Law School. She specializes in public international law, the law of armed conflict, international negotiations, and counterterrorism. She is also the faculty director of the Program on International Law and Armed Conflict and a member of the Program on Negotiation Executive Board. Prior to joining the Harvard faculty in the fall of 2005, Blum served for 7 years as a senior legal advisor in the International Law Department of the Military Advocate General Corps in the Israel Defense Force, and for another year as a strategy advisor to Israel's National Security Council. Blum is a graduate of Tel Aviv University, LLB and BA in economics, and Harvard Law School, LLM and SJD. She is the co-author of 2 books, The Future of Violence, Robots and Germs, Hackers and Drones, Confronting a New Age of Threat Law, Outlaws, and Terrorists, and recipient of the Roy C. Palmer Civil Liberties Prize. And the second book, Island of Agreement, Managing Enduring Armed Rivalries. She's also the co-author of journal articles in the fields of public international law, international negotiations, and the law and morality of war. She was awarded the Carnegie Fellowship to work on a book manuscript called The Fog of Victory. Professor Blum, it's a pleasure to have you here to moderate the session. The microphone is yours. Unmute.
Thank you. Thank you, Yaniv, for unmuting me and for introducing me. And thank you for Shula Gilad for inviting me here, and Abigail and all the other organizers of this important event. It is a distinct pleasure and honor to introduce our speaker and my interlocutor for today, former President of the Israeli Supreme Court, Aharon Barak. And, you know, in some sense, Aharon Barak needs no real introduction to this forum. And yet, I think as a background for this particular conversation, it would be apt to nonetheless say a few words about Justice President, Professor Barak, and his unique place in the history in not only Israeli law and constitutionalism, but really of the state of Israel as a whole. So Justice Barak was born in Lithuania and often remarked on his formative experiences as a child survivor of the Holocaust. The family later arrived in Jerusalem, and Barak completed his studies of law, international relations, and economics at the Hebrew University in Jerusalem. His intellectual brilliance shot him to academic stardom, and at the tender age of 36, he was named the dean of the law school of the Hebrew University in Jerusalem. And 2 years later, at the ripe old age of 38, was awarded the Israeli Prize for Legal Research and was inducted to the Israeli Academy of Sciences and Humanities. 2 years later, Barak was named Attorney General of the State of Israel, and a brief time later was appointed to the Supreme Court, where he served until 2006 for 11 of those years as the president of the court. Though Barak was and is a brilliant scholar of numerous fields of law, his national and international fame is primarily rooted not in his scholarship, but in the many opinions, many revolutionary opinions on the Supreme Court of Israel, and his general perception as the father of the Israeli constitutional revolution. Barak is widely thought of as an overwhelmingly activist judge. During his time on the court, he rejected many judicial doctrines widely accepted in other constitutional courts around the world that limit judicial review of legislative or executive acts. Through expansion of the right of standing, Barak allowed individuals and organizations to petition the Supreme Court in its role as the High Court of Justice, even when those petitioners were not individually harmed by a decision, but merely standing as public guardians of the rule of law. In a near elimination of categories of injusticiable or political questions, he opined that all disputes can be viewed through the lens of law, and that in a democratic society, it is not only possible and proper, but also required that the court pass judgment on the decisions of the other branches. Especially salient for contemporary debates is Barak's development and expansion of the test of reasonableness as a cause and standard for review of administrative decisions. It was in reliance on reasonableness that the court, among other rulings protecting human rights and the integrity of the process, also barred the appointment of ministers or deputy ministers who face criminal indictments. With the enactment in 1992 of the two then new basic laws, Basic Law Human Dignity and Liberty and Basic Law Freedom of Occupation, Barak expanded the judicial review power of the court to cover not only acts by the executive branch, but also legislative acts by the Knesset. And even though in practice to date, only a total of about 22 laws were struck down by the court, and many of them after Barak had already retired, the expansion over time of the court's readiness to review both government policies and legislative acts has drawn fierce criticisms from different camps of Israeli society, who felt that the Supreme Court has assumed an outsized role in the delicate ecosystem of checks and balances vis-a-vis the elected branches, and has become a de facto alternative legislature. Such criticisms were often complemented by claims that the court, in both composition and judgment, was tilted ideologically towards liberal, secular, more left-leaning values, which left swaths of the Israeli public alienated or disgruntled. On the left side of the map, too, there are those who argue that Justice Barak was revolutionary for Israelis and predominantly Jewish Israelis, but that he helped legitimize and solidify the continued occupation of the Palestinian territories. We will undoubtedly discuss some of these themes in today's discussion. For now, I'd like to conclude with this. Whether or not one fully embraces Justice Barak's judicial philosophy or legacy for the court, one cannot deny that Barak has had a transformative and unparalleled role in shaping Israeli law and political culture, in delineating the do's and don'ts of a legitimate government, in a democracy, in ensuring that the will of the majority does not turn into a tyranny of the majority, and in making the High Court of the land an accessible hall for ordinary citizens to voice their grievances. For all of that, he became a hero not only of large portions of Israeli society, but also of judges, lawyers, and champions of democracy around the world. As such, there could be absolutely no one better suited to address and opine on the substance of the proposed judicial reforms now tearing through Israeli society. Justice Barak, thank you for your willingness to share your insights today. I know we are all extremely eager to hear from you.
Thank you. Thank you very, very much, Gabi. And thank you for giving me the opportunity to talk with you. I would like to make three introductory notes, and then you will start, Gabi, to ask me the questions you want to ask me. The three introductory notes are the following. The first one, I think for an American audience, it is complicated and strange in a way to understand what's going on at home, because the constitutional structure in the United States and the role of the court in the United States is different from the constitutional structure and the role of the court in Israel. So let me make very few remarks on this first point. To start with, in Israel, we don't have a true, real separation of powers, a true, real checks and balances, which you in America had. I hope you still have it, but that's another question. That's your problems. I'm now talking about our problems. In Israel, being a parliamentary system, the government controls the parliament. A parliament cannot make a decision against a proposal of the government. If a member of parliament does not comply with what the government told him to do, the member of parliament cannot be ousted from parliament, what will be ousted from any position he had in which allowed him to resist the decision of the government. That's the system of being a parliamentary system, and a system in which the members of parliament were appointed by a list created by the leaders of parties who are members now, who now control the government, control parliament, and they control the government. So that's the one point. Another point is that in Israel, for many, many years, starting Ben-Gurion, Begin, and now Netanyahu, the prime minister controls the executive branch. All disputes, there is an outcry, the prime minister has to make a decision. All the ministers are appointed by the prime minister. In this respect, they are similar in a way to secretaries appointed by the president of the United States. So basically, executive branch and legislative branch, there's no separation. There is only one power in Israel, the prime minister. And the second branch, which controls it, is the court system generally, and the Supreme Court of Israel specifically. So please, this is the background in which you must put behind yourself when you understand the problems we have here in Israel. When the demonstrators here in the streets say we are against the dictatorships, they know what they are talking about. The dictatorship means that we are going to have that all the powers will be in the hands of the prime minister, and there will be no control of those powers. And the judiciary will not be able to exercise its supervisory role of separation of powers, of checks and balances. So that's one point to take into account, the difference between Israel and America. In America, you have, like in England, a culture of running a country. There are things that are not done. In Israel, we don't have a culture of running a government. 2,000 years in the diaspora, educated us to run a shtetl, but they did not educate us to run a country. And you feel it very, very, in all areas. It's not done, is something which is not recognized. You can be charged on severe crimes. You can be even convicted of Supreme Court. Unless it will be not legal for you to continue in office, you will continue in office. Take it as something which exists, regrettably, in our situation. The Israeli society, the third point, understands democracy on a very shallow understanding. For them, democracy is the rule of the majority. You ask a guy in the street, he will tell you what democracy is. It is 64. We have 64 members. Therefore, we can do whatever we want. In the Israeli non-culture, democracy does not mean, in addition to, of course, the rule of the majority, the demos, the rule of the people, it includes also, for example, rights of the individual. No. Rights of individual is not something which for them is part of democracy. It's something outside democracy. Either you have it or you don't have it. Lastly, we are a country which is under tremendous security problems. Every day, and Gabi can tell you with her knowledge from the Israeli side, she can tell you every day at least 50 attempts for terrorist activities in the country. 99% of them are prevented because of our intelligence, but one passes. Now, when you have a situation when the individual is in threat of his personal security, both his own security and his family security, you can understand that to think about the rights of others is not the thing that's has a primary position in his mind. No. And therefore, when I decided that torture is unconstitutional, was illegal, this shocked many, many people. How come? But we need it in order to keep security. We need it in order to catch the terrorists. Yes, but we have to protect human rights, and human rights, the importance of protecting human rights, again, as Gabi knows very well, is the rights of the guys we don't like too much, etc. So that's my first point. Please, when you ask yourself if to join the reform or the anti-reform, you must understand that it's on the background of special problems that the Israeli society has. That's my first point. My second point is the following. Israel has built its constitutional ship on the high waters, not in the dock. And that's a tragedy. It's a tragedy because what is a basic law? What is our constitution? The Declaration of Independence, the Israeli Declaration of Independence, which has a more important role in Israel than the American Declaration of Independence. The Israeli Declaration of Independence, it provides that Israel is both Jewish and democratic. Let me summarize this. And it also says that within 4 months, there will be elections to a constituent assembly that will create a constitution. Well, these elections didn't take place because there was the War of Independence. But in 1949, when the War of Independence was over, elections took place and a constituent assembly was elected. And there was a dispute there what to do with the constitution. And ultimately, they make a historic decision, not a constitution, yes, but not now. We'll do it chapter by chapter. Every basic law is a chapter. At the end of it, they will be combined together, and this will be the Constitution of Israel. So what is a basic law? We don't know. How can you constitute a basic law? Can a Constituent Assembly, which means our regular parliament, because when there were elections to the Constituent Assembly, the Constituent assembly, which was elected, was the only elected body. There was no parliament. So they took on themselves, they have two heads, both a constitutional assembly and a regular parliament, which of course is very bad, but that's the situation. And what happened is we don't have rules about how to write a basic law, which is the majority, the basic law enacted. And what was decided by the court, and I understand the courts making this kind of decisions, that the basic law is a document which is called basic law. How do you enact a basic law? Nothing is said. Okay, you enact a basic law as you enact other regular statutes. You change a basic law the same way you change a regular statutes. So forget about the American Constitution. We don't have it. Forget Article 5 amendment clause. We don't have it. Basic law, human dignity and liberty, and basic law, human dignity and liberty can be amended by a vote of 1-0, because we don't have quorum problems in our parliament. 2-1. Can you imagine? And this is what they want us to do now. They can rush like a blitz to make all those amendments in 1 week. They can do it because quickly, what they need is the majority. They have the majority 64, and that's the end of the story. One should not forget it. What we need very deeply is a basic law about how to do basic laws. And we don't have it. We missed the opportunity to have it. You know, Mount Sinai #1 was when we were in the desert. Mount Sinai #2 was supposed to be in 49 when a constitution was, when a constituent assembly was enacted to write a constitution. We missed it. It did not happen. And what I think we need now is to utilize this a constitutional moment we have now, a constitutional moment in which we can now ultimately make the major decisions, how you make a constitution, what will be its content, what will be its chapters, etc., etc. And I think it will be, we will miss the whole thing if we will find a compromise with the president within the president house to problem A, problem B, problem C, postpone the others, etc. What we need is to have now to put our constitutional ship on the dock and to build it from the beginning, from ABC. Now, it doesn't mean that we can and we should now, and the demonstration should now ask for a full constitution. It's impossible. Because many problems which are, on which a full constitution has to deal with, we haven't discussed it in the country. It will take months and months and maybe years and years. Will we be a parliamentary system or a presidential system? Will there be one house or two houses? How will be our voting system? Will it be the proportional voting system or some other system? There are so many open questions. So what we need to do now is a new basic law, utilizing this constitutional moment in which we are here, which will say what is a basic law, what happened to the old basic laws? Can you amend them according to the old system or according to the new system, etc., etc. I myself prepared such a basic law, and I sent it to the president, so he knows what can be done, and I think what should be done. And then we have to add into this basic law legislation, we have to add, of course, how to appoint judges. Now, here again, you must understand the difference between the Israeli legal system and the American legal system. The American legal system to appoint a president is a nomination by the president, a judge of the Supreme Court, any federal court, but let's say it's Supreme Court, nomination by the president, approval by the Senate. And you have two different checks and balances, branches. That's part, the main part of the American checks and balances. We don't have it. We don't have it. So what happened for many, many years, the appointment of judges was done by a special committee in which of 9 members, 2 ministers, of course, politicians, 2 members of parliament, politicians. The constitutional tradition, custom is 1 from the opposition, 1 from the coalition. 2 lawyers appointed by the Israeli Bar Association. In Israel, we have only 1 bar, not like in the United States, in which you have many bars. You have only 1 bar, and one of their main, their body is what they have a body to appoint these two lawyers, and 3 judges of the Supreme Court, the president of the Supreme Court, and 2 other judges. And the rule says that in order to appoint any judge in Israel, but judges of the Supreme Court, you need 5 out of 9, at least. And to appoint judges of the Supreme Court, you need 7 out of 9. And you have a very interesting balance in it, because instead of the separation of powers of nomination and consent you have in America, you have here an internal veto. The politicians cannot appoint a judge without the agreement of the 3 judges, because they will not have 7 votes. The judges cannot appoint anyone against the view of the politicians, because if 3 votes, even if you add to it the 2 votes of the lawyers, and even if you add in the minority, the opposition member of parliament, will give them 6, they will not have 7. So you have a very interesting balance. What one wants now to destroy is all this balance. They in the beginning wanted that the coalition can appoint all the judges. Now they want that the politicians, which means coalition and opposition, can appoint all the judges of the country, including the judges of the Supreme Court. Now we have the idea of seniority. You don't have it in America. Warren was appointed to the Supreme Court and Chief Justice. But we have another system. And under our system, we have again a constitutional custom of seniority, which means the senior judge, the oldest judge in terms of his time on the Supreme Court, is appointed. I was appointed president of the Supreme Court, not because I'm a clever judge or the best judge, but I was appointed to the court when I was young. And so slowly, it became my turn. And that's it. And for us, it's so important that seniority will be kept, because the moment we will not have seniority, the judges will start to run to the politicians. I know it. It happened already in the past, and we should prevent it. So that's my second point. And my last point, a very short point. I don't say that all the judgments I wrote, and which Gabi referred to, some of them are the best judgments, that I haven't made mistakes. We hope judges are human beings, so they clearly at some point make mistakes. I hope only that if I made a mistake, I can correct it, that my mistake didn't kill someone. Therefore, I'm against death penalty. In other cases, I hope to correct it. And one who reads my judgments, I express this idea that judges are making mistakes, and they should correct the mistakes if they, of course, can do it. And in many, many cases, they can do it. So we have a situation here in Israel in which we have judges. The role of the judges is different in some ways, not all the way through, from the role of a judge in the American Supreme Court. I was very close to Scalia. We were very good friends. But Scalia was a judge for the Americans. he will not be a judge. He could not be a judge for us. Because we don't have this culture, which is so, and separation of powers, which is so presented and present in the United States Supreme Court, and which you don't have it at all in Israeli Supreme Court. So if I look at my judgment, I know that I made mistake. Other of my colleagues made mistake. I know that we need a reform, but not the one they have done. The reform we need is more judges. More judges. You have almost 1 million cases per year coming to the Israeli judiciary. Too much, too much. We need more judges. We need a reform in the jurisdiction of the Supreme Court. Israeli Supreme Court hears 9,000 cases per year. Can you imagine? To hear, not just to decide certiorari denied, but to hear them. It may be a short hearing, it may be a long hearing. We need to change all this. I was in favor of, and I presented suggestions to Parliament to have a system in which many of the powers of the Supreme Court shall be delegated to lower courts, even to the magistrate court, which is the lowest court. The Israeli Supreme Court acts both as a first instance court and an appellate court and a Supreme Court. All these things shall be amendment. But the reform that we are now faced with is not doing this kind of job at all, doesn't touch it at all. And I'll finish with that. I know that I made mistakes. I know also they want to change many of my judgments. That's not my point. I'm not against any change. I always said, for me, law is like an eagle in the sky. Law must move. If an eagle stops flying, stops moving, he falls. And so also law must move. And of course, I understand the judgment I gave 20, 30 years ago will be changed in due time. That's fine with me. That's fine with me. But please make the proper changes. And I hope you now see how difficult and complicated the role of the Israeli judge generally and the Israeli Supreme Court judge is especially. It's a very complicated. The pressures of society are tremendous, and the means are very limited, because our constitutional ship was created in the improper way. And I know there is a lot of criticism against me. And I know that, and I wrote it in one of my judgments, when I sit on trial, I myself stand trial. Yes, I know it. But my judges will not be public opinion of today, neither of the demonstrators in favor of me, my ideas, and nor did those who demonstrate against it. It will be history that I will be judged by. I hope I have, a small hope. I hope they'll judge me generally favorably, but who knows? Okay, that's my introduction. I think it was too long, but I leave time for questions. And so if we go more than an hour, I will be in your hands. I reserve the time.
Justice Barak, thank you so much. I see people clapping on mute, but you should hear the clapping spiritually. So thank you for that. I want to touch on some of the themes you raised in this great exposition. Maybe start with the fact that, I completely agree that the comparisons to the United States are just bogus and completely irrelevant. But reformers say that one could point to many other democracies, mostly those with a written constitution, but also parliamentary democracies in which this idea of separation between the executive and the legislature is more tenuous than in the United States, and where the role of the Supreme Court nonetheless is less salient or less proactive than it is in the state of Israel. And some of it is about judicial review, and some of it is about some political participation or oversight of the appointments of judges. Do you think that our current model in Israel is the only balance correctly struck, or could there be some nuances in the power of the court, or the way judges appointed, or the ways legal advisors are appointed by the head of agencies or ministries, that would nonetheless satisfy a democratic society?
Well, it's a very important question you ask. My answer, I think, is the following. I always said that the rulings as we have them now are for our times now. It's not forever. The situation will be changed, may be changed. Also, the judgment will change in this respect. And I understand there are other democracies, which are parliamentary democracies, with or without a constitution. Without, I mean, it's England and UK and New Zealand, basically. And but England is subject to the European human rights jurisdiction, to Strasbourg. I understand that there are other other countries in which you have other systems. I'm not saying ours is the best system for everyone. I think ours is the best for our system as it is now. As it is, there is place for change. I hope that when we will change our election system, and people will be, and members of parliament will be responsible not only to the political appointments, but will be also responsible to the people who voted for them. Things will change dramatically. And Ben-Gurion wanted to do it, but he was able to achieve it. We are now in a situation in which what happened in Turkey, what happens in Hungary, and what happens in Poland is very much in sight. And we should learn from their lessons. Whenever this illiberal democracy, as they call it, for me, an illiberal democracy is not a democracy. And to achieve this illiberal democracy, they said, they understood very well, rightly so, what they need is to control the appointment of the judges. The moment they control the appointment of the judges, controlling this constitutional court of Hungary, of Turkey, and of Poland. And you know, I was very friendly with the chief justices of all these three countries, and I understand what's going on there. And the moment you control this, the court, you control everything, because then they will legislate every amendment to the constitution, and the court says fine. So I'm not saying, Gabi, that our system is the only system that a liberal democracy can have. No. But I think our system is the best system for this country, which is only 70 years of age, which has a long history, but very few values how to run a democratic regime, and other problems and security problems that I have mentioned.
Great. Next, I want to try and tie two different themes and see if they cohere into a single question. You alluded to the motivation or the need for judicial review by reference to two problems. One is the lack of a constitution, the lack of this, well, can call it structural demands of the system, the non-separation of power, the lack of a written constitution, etc. And then a more, you can call it cultural reasons about norms of government, about, you know, is there a tradition of this sort of do's and don'ts? Is there a tradition of shame, of taking responsibility? And I think a legitimate question would be, you know, for many of us in the traditional elites, your role as a public educator was entirely welcome and embraced. But you now have a majority, including in the elite, that doesn't share your cultural values, that doesn't share your beliefs in the do's and don'ts, where a majority of the population voted again and again for a prime minister facing indictments, for ministers previously convicted of crimes, for people who were prior convicted terrorists. And there is now, so if in the past one could say that the court's ultimate decisions aligned with a majority of the certainly elites, you know, what happens when the current majority, including among the ruling government, does not share those values? Can the court remain playing that role of a public educator without losing its entire legitimacy?
Okay, here's my answer. I think that what we were doing in the court, myself and my colleagues on the Supreme Court, is expressing as what we understand are the values of our Declaration of Independence. Not our personal values, but the values of the Declaration of Independence. And the values of the Declaration of Independence are basically that Israel is the national home of the Jewish people in the whole history, etc., Holocaust, etc., and that we are aiming for democracy, though the word democracy is not mentioned there, democracy in the sense that all our citizens, and especially mentioned the Arabs, will have equal rights in Israel. This is our DNA. And this DNA is injected in our Constituent Assembly, which was elected according to what is said in the Declaration of Independence. You see the difference between the American Declaration of Independence and the Israeli Declaration of Independence. In Israel, the Declaration of Independence itself says there should be a constitution, and it's to be written by a body that will be appointed. And it's quite clear to me, that's my theory, that the DNA of the Declaration of Independence is the DNA of our Constitutional Assembly. And those who are arguing, the 64 members, that we have the majority and therefore we can do things that are not authorized, that are not mentioned in our Declaration of Independence, if we want it, this idea is, I think, they just can't do it. If, for example, there will be a statute that Israel will annex the Area C in the West Bank, and those will be Israeli members of the Israeli society, but they will not have a right to vote. I think this, our parliament, our Constituent Assembly, which will annex such a basic law, they just can't do it. And I'm not taking now the examples, you know, that the red-headed cannot vote. It's not red-headed. I'm talking about things that can happen tomorrow. I know what I'm talking about. So I'm asked, okay, but basically you asked it, but the people don't share those views now. My answer is, ladies and gentlemen, if you don't share the views of the Declaration of Independence, as I understand it, write a new Declaration of Independence. Please do it yourself. And write a new Declaration of Independence, says expressly what you want. Arabs have no rights, etc., etc., etc. Do it. I myself think that they will have problems in doing it. I don't know what the Supreme Court will say about this new Declaration of Independence, etc. And they don't want to say it. What they say, what we are doing is written in the Declaration of Independence. Okay, this is a legal question. What is said in a document is a legal question. And the Supreme Court of Israel said what is said in the document, that Israel is a Jewish and democratic state, and it repeats this in several basic laws. And it also said it's both Jewish and democratic. It's not a Jewish state with democracy. It's not a democratic state with Jewish values. And it's not and or. You know, we say in Hebrew, oy vey. It's not o, ove, no, and or. It is both of them. And I wrote several judgments explaining why we can achieve this end without an eternal contradiction. But that's not it. time now to discuss it. So what my answer to your question is, I understand these questions, but you cannot achieve your values, which are based on majority and only on majority, only on the power of majority. You cannot achieve them under the existing Bill of Rights, under the existing Declaration of Independence. It doesn't follow from it that I think that the Declaration of Independence is a super constitution. That's not my point. What I'm saying, the Declaration of Independence, the DNA of Jewish and democratic state and rights of minorities and individuals is injected from the Declaration of Independence into the Constituent Assembly. Thus, my view is that the Israeli Constituent Assembly has not, its powers are limited, can be limited by some basic ideas of democracy and Judaism. It may be limited, that they don't have, they cannot do whatever they want.
Okay, so let's flip the prism now of who's the minority and what its grievances are. And, you know, there was a poll I saw from the last few days about sentiments in the Jewish Orthodox community. And I think for many of us in the sort of secular camp thinking about the ultra-Orthodox or the Orthodox as a minority when it has sort of an outsized political power is interesting. But from their point of view, the promise of guarantee, or at least that's the claim, the promise and guarantee of rights and protection of the minority from the tyranny of the majority has mostly safeguarded secular Jews. It could be gay rights, it could be people with disabilities, certainly women to a great degree, not as a political minority, not as a numerical minority, but that Orthodox got the shorter end of the stick. And that is a harder theme to solve by reference to the Bill of Rights or human dignity and liberty. This dual commitment to the Jewish democracy that but you're not correct that it is also a justiciable question in the sense that one is able to address it through the lens of equality or discrimination or favorable treatment, but that in some sense, whether or not the Haredi population is called for service, just as much as whether the Arab population is called for service, goes to the heart of political deals and political kind of consensus or at least coalition building in a way that you really cannot intervene. And when you intervene, it seems to be against that sizable minority.
Well, so you bring me back, I think, to what does the Declaration of Independence mean when it says Jewish and democratic? How do we understand those two ideas? And my understanding of those ideas are the following. Israel as a democracy means those values which are common to democracies, which are independence of the judiciary, human rights, the rule of law, separation of powers, etc. What does it mean Israel as a Jewish state, or the values of Israel as a Jewish state? My answer to it is, and I expressed it also in my judgment in the Kadan case, my answer to it is, as I interpreted the Declaration of Independence, apropos, that Jewishness means those values which were developed by Jews all over the world, but whether it was in Palestine before the conquer by the Romans, and whether it was in the diaspora. And this is a very rich volume of legal, because there were questions and answers, two rabbis, of legal questions, which says what Jewish values are. For me, Jewish values are basically two types. They are moreshet, traditional values. So you start with the Bible, and you start with it, all the religious writings. I accept them as the values of Israel. But those values, and also the Zionist values, for me, also Zionism is a Jewish value. It's not just a democratic value. And Nachem Elon, who was a religious judge on the court, that was his idea. And I agree. I have problems with him in other matters, but not on this major matter. So when I'm saying that Jewish values, those are values which were developed in 2000 years or so. And they are contradictory inside of it. It's so rich that clearly it has the contradiction. Take the question of the rights of women. On the one hand, terrible. The woman has no rights, etc., etc. On the other hand, it's the pearl in the crown. Take the non-Jew. On the one hand, kill them, kill all of them. On the other hand, one moment, he's our best neighbor. We should give him the rights that we have. And why do we have so many different different attitudes in Judaism? Because they express the needs of the Jewish society in the shtetl and the Jewish society when it was making its move within the path of the diaspora. So when I come now to the question, what is the attitude of Israel as a Jewish and democratic state concerning women, for example? In democracy, equality. In Judaism, there is equality and there is not equality. There is discrimination. Okay, I pick up equality. I'll pick up from the Judaism that which fits democracy, and vice versa. Apropos, I'll pick up from in democracy. You may have different kinds. Let's say, to what extent is there a wall between state and religion? So you have the American and the French attitude towards it. It's not the Jewish attitude towards it. So if you have in democracy, a democracy like an American French democracy, but you have also a democracy like the English democracy. The English king is the head of the church, of the English church. So there's no separation between state and church. So I said in Israel, because in democracy you have different attitudes, in Jewish law you have only one attitude, no separation, I will go with the Jewish. But I said, to the extent that you give services to the Jews, you have on equality to give also religious services to the non-Jews, etc., etc. So here is this, I build it up. It's not, my views are not just systematic views because of separation of powers. My views are coming deep, deep in the values of Israel as a Jewish and democratic state, and in trying to give meaning to those two values as I understand our Declaration of Independence.
Okay, so I think I'm allowed one last question before I turn it back to Yaniv to call on our attendees. So I want to ask you about where we stand at this constitutional crisis moment, and what would be your advice to the sort of protesters camp? And let me see if I can articulate it in a way that makes sense. When I look at it, I see one camp of the reformers that seems to have a coherent worldview of what the state of Israel should look like. It's more Jewish, nationalist, populist, where, you know, the end game vis-a-vis the Palestinians is one where there is annexation, as you suggested, maybe a one-state solution. Whereas on the protester side, one of the great prides that protesters take is in the more heterogeneous composition that includes sort of traditional Likudniks, the more sort of traditional conservative, as well as some from the religious communities who say, you know, having an independent judiciary is an extremely Jewish value. And it is but so it's all cohesive and coherent around the reforms, but I fear that that consensus would sort of evaporate once you sit down to talk about what is the future constitution of the state of Israel. And as you said, a full constitutional convention, negotiation, vote is a very long-term game. At this moment, what is your advice to the people on the Zoom call, the people in your community? Do we fight over each and every provision just to maintain the status quo because any breaking of that balance is too precarious, or there is a possibility of some compromise? And I'll note that you have a real reputation for consensus building, not that you shy away of controversy, but that your initial instincts are one for building consensus. At this moment, should we strive for consensus, or it's too, you start shaking, moving too much, and the whole building collapses?
Okay, so from the factual point of view, I'm in contact with the leaders of the demonstrations. I meet with them, they come to me. I'm in contact with the Israeli law professors who represent the demonstrators in one way or the other, with the president in President House. I talked several times with the president himself. I myself am in favor of trying to reach an agreement, not to fight it out to the dead end, so to speak, because the dead end is either blood or that the whole question will come to the court, which is not a good idea.
No.
Because with all my views about what a court should do, don't expect the court to create a full constitution for the state of Israel. It cannot be done. So what I do think is that the demonstration should go on, because they are our iron wall. If not the demonstrations, and especially by the army people and by the high tech, etc., they would continue with it. They don't care about our views about it. We care about their views. I care about their views, and therefore I think the demonstration should go on. They should not move into a full constitution. It's too much. They should not deviate to try to create a new political party which will be against this 64 majority. No. We should try to find out how things can go on, that we can agree. And therefore, I was in favor of the whole idea to go to the president. I told the president, look, you are now making a negotiation. I mean, that's what you are doing. There is a theory of negotiation, how to do negotiations. I told him the way I conducted the negotiation in Camp David. I learned a lesson from that, how to do it here. And I didn't hear, so he knows that there is a problem there. And therefore, the idea that the two major parties are now went out from the negotiations at the President's house, I do hope they will come back at some point. And yes, as you mentioned rightly, I think, I don't think I know everything, and so I'm in favor of a compromise. But there are things that cannot be compromised. The appointment, the committee appointing judges cannot be compromised, because the moment you compromise you compromise on the whole thing. You lose the whole thing. Seniority includes. And you should not compromise on major items, but on non-major items. I think that we should sit down and talk at the President's house and to see a way out of it. But they should know that if they continue to talk and disagree, that the number that the demonstrations will not go down, they will go up. We have built a system. This demonstration is really, books will be written, of course, about it. You have a situation of some 150 organizations which are together. And if you need some support in point A, someone says so, then immediately in point A, in Metula, someone comes will fulfill what is needed. So they are very, very much organized, good, in good spirit, and they understand that they are fighting for the existing of Israel as a Jewish and democratic state, also Jewish. And so you have some religious guys, of course, who participate in this election, in this demonstration. So there should be red lines which should not be crossed. And the most important red line is the seniority, because the moment some of the ideas is, okay, you know what? So you will have something and we will have something, and then the president of the Supreme Court will decide. No, I don't want the president, because I know whom you think the president will be. So the seniority business, which is a non-American idea, and the appointment of the committee, the checks and balances in the appointment committee, which fits the general idea of nomination and Senate by two different bodies. And having everyone a veto. The Senate cannot appoint someone that the president didn't nominate, and the president can nominate, but the Senate may disagree. So having a kind of similar situation in Israel, I think those are red lines which should not be crossed.
Thank you very much, Yaniv. I'm passing the baton.
Sure. Thank you very much for this fascinating discussion and for defining the red lines in the discussions going forward. Much appreciated. I'll open it up for questions. There have been a lot of people who've been trying to ask some questions. We'll also read some questions from the chat. Whoever is asking a question, please make it as short as possible, and to make sure that we have enough time for everyone to participate. So the first one is Guido Calabresi. I hope I didn't, I pronounced your name correctly.
Guido. My friend Guido.
Yes, Guido Calabresi, judge of the United States Court of Appeals from the Second Circuit. I just came back from the judicial conference of the Second Circuit, and the topic of discussion was on the attack on democracy all over the world. After much discussion on that, it turned to the role of judges and the need for independent judiciary to be at the last moment there to protect democracies in every different type of country where some group takes power, perhaps properly, perhaps not, but tries to use that power to keep others from changing and taking over. And that only the judiciary, if independent, could step in and protect that democracy. What is done is different in different countries, but I've got to say, Aharon, you were there, and everybody was aware of what you had done and tried to do. So that's my greeting. Hello.
Thank you, Guido. He's my best friend in the United States is Guido. He brought me to Yale. He was then the dean, and we keep in touch all those years. Guido is a Finzi Contini member, and I as an Israeli, and we love each other. And thank you for what you said, Guido.
Oh, my apologies. I was on mute. Ayala Linder, please ask your question.
Okay, I'm unmuted. Shalom, shalom, Aharon. This is Ayala Linder. You knew my mother very well, Yocheved Linder. She was your secretary. And I'm here in Miami, yes, many, many years ago. I used to play in your office as a little. So you mentioned that you meet with leaders of the organizers of the demonstration, okay? Many times in history, a society is destroyed by internal strife rather than an outside enemy. And we know that, we know what has happened in Israel many, many times. It's known as sinat chinam, a brother against brother. So my question to you really centers around is, as far as Jews and Israelis in the diaspora, which I've been here since the 70s, what is your take on, people from outside? It's sort of like this is a fight between Israelis, and how does that look worldwide on the Israeli populace, on us as a country, when we are so divided? Do you think that that presents a weakness point to which our enemies can take advantage as we are fighting each other, number one? And number two, do you meet with organizers from both sides of the fence and trying to mend these issues, looking for peace?
Okay, so I'll start with the second question. Yes, I meet with both sides. So I, of course, as I mentioned, I have met the organizers of the demonstration with others. But look, I am now, I have no official business. I sit at home at the age of 86 and trying to survive. And but I'm interested, and they want to talk with me. And I think I have some influence on them. So I talk with them. I also have talked with the leaders from the reform, not with many of them, but Ron Dermer, who is really the member, the hand of Netanyahu in the president house. I had a long discussion with him. We are friends from many, many, many years ago, before he became an ambassador, when he was just in Israel. And so we are. I try to talk with everyone, not only with one. If one doesn't understand the other side, it's difficult to reach an agreement. One has to understand deeply what they are all about and what really matters for them. And this is very difficult to say, because I don't know what really matters with the Minister of Justice. It's very difficult for me to enter into his mind, because this person for 20 or 30 years ago already decided that he wants all these changes. What happened? Why is it? What runs him? I don't know. And I don't know. I don't know what runs Netanyahu. Netanyahu can finish it if he decides to finish it. He can, but he doesn't. Why? What runs him? Is it his fear to break the party? Is it his fear from the court? His indictment? I don't know what's going on, and so it's very difficult to know who your adversary is. Now, as far as your first question is concerned, of course it is an Israeli issue. That's right, but the non-Israeli, the Israelis who are abroad, you can help us. Israel was always built as the homeland of the Jewish people,
Yes.
Not just the Israelis who are here, but every one of you really has, those of you who are Israelis, you have Israeli citizenship anyway. Those who are not Israelis, Jews who are not Israelis, but you can become Israeli on your volition under the law of return. And so one of the reasons why Ben-Gurion did not want a constitution in 1949, he said, look, we are now here 600,000 people, and we are going to write a constitution for 30 million people. We can't do it, etc. Okay. So now the numbers changed. And however, yes, we should take into account, and I'm taking into account, I think the demonstrators are taking into account, if the guys who run the reform care about what Jews all over around the world think, I'm not sure. Why I'm not sure? Because I don't know what goes through their mind. It's very difficult. I am the enemy of the people. You know, there were demonstrations before my house, and this main slogan was, "You should retire." Yes, ladies and gentlemen, I retired in 2006 when I was 70. And now I'm 86. 16 years passed. I retired. What do you want from me? I don't know what runs them. Abak.
Thank you, Ayala. Thank you, Justice Barak. I just want to make sure that it's okay with you that we continue for a couple more minutes, because there are a lot of people who would like to ask some questions. With that, I would add Abigail Gilad, one of the organizers here, and to ask some questions from the chat.
Okay.
Thank you. I'm just gonna, there are a lot of them, so we've chosen just a sample. But essentially, Uri is asking, why did the Supreme Court never tackle explicitly the conflicts between Israeli actions and laws to the international law? Specifically when it comes to the settlement movement, and in general, how do you look at different structures of law, either in Israel, the West Bank, and also as it pertains to international law?
Well, if you take judgments I wrote, I tackled with these questions. I thought I wrote many judgments which were basically trying to reach a solution according to international law, international humanitarian law. You are right, or Uri is right, in assuming that the main question, namely, does the Geneva Force Convention apply to the occupation in the West Bank? Does it or doesn't it? This question the court did not decide. There are several judgments, both by Justice Landau and by Justice Shamgar, but they haven't decided it because the government came with a declaration before us. Leave this question open because we undertake to fulfill our obligation. Even if the Geneva Force Convention applies, we will comply with it. So check us. And we do check them. And so under this assumption, yes, we went very deeply into international law on these matters. When the question of the wall was adjudicated, it was according to international humanitarian law, the Fourth Geneva Convention. When the question of the target killings came up, it was according to the second protocol of the Fourth Geneva Convention, and all those decisions were decided according to international law.
I think one of the main fears of this reform is that it will leave a lot of, Israeli, even the soldiers in Sahel, very at risk with international law. And so I think this is a segue also to a question, what is it by Adam Wyszkowski, and please expand if I'm not accurately conveying the question, is what is an example of no major item? And I'm assuming this means what are the things that we cannot concede to the I'm blanking on the word, but what can we not concede?
Well, look, I haven't heard that the reform that Israel wants to enact a basic law that we are not bound by international law. They haven't said so. So I do assume that they understand that we are part of the international community and we are subject to international law. They also understand that if there is not an independent court in Israel, then cases, then Israelis, mainly very high officials of Israel, whether political or military, can be indicted by the International Criminal Court. And so, and they know it very well. And the argument is made here is don't touch the court, don't touch the independence of the court, but because the moment the Israeli Supreme Court will not be independent, then the ability to indict the heads of our security and military and political branches may be exercised in reality. This is something which, with this kind of argument, is brought within the dispute between the different parties. They know in Israel that the Supreme Court, in a way, is the Iron Dome, so to speak, against indictment by the International Criminal Court. But this on the assumption, only on the assumption, that Israel does fulfill its obligations. That if there is a violation of a claim of violation, they check it by an independent way, which I wrote in my judgment on target killing, by an independent body. And if this independent body finds that violations were done, they are put on trial. If Israel will do all this, then the fear that the Israeli officials will be indicted by the ICC is less. It still may happen, but it's less.
Thank you.
Thank you very much. Ruth Kaplan, please ask your question.
Thank you. Justice Barak, it's a pleasure to hear from you. Our family are very close friends of your colleague, Ellie Rubenstein. And I know how much you two have enjoyed working together. I have a couple of questions. One is very relevant for today, of course, is the issue of reasonableness, which I know that in hearing people comment on it, even some journalists who I thought might do a better job, they talk about it as though it's a subjective standard, which I know it's not, but I thought it might be helpful if you could opine on the importance of that and whether that's one of the areas that's a red line for you or not. And my second very quick question is, I've heard people critique the selection process for judges on the High Court as saying that it produces a majority of Ashkenazi judges versus Mizrahi judges. So could you comment on those two questions? Thank you so much.
Thank you. Now, as far as reasonableness is concerned, I think it is a red line, but there's a lot to be said about reasonableness. You know, I'm the one who introduced basically reasonableness into in the modern way of thinking about reasonableness in constitutional law. There was reasonableness in administrative law, etc. And it's shocking to me that someone can assume that a public official who has a duty of trust to the people can behave in a very, very, very non-reasonable way, in an extreme non-reasonable way, because this is the criteria. And you are very right, reasonableness is an objective criteria, it's not a subjective criteria. I know all the criticism on it. I myself have written somewhere else that proportionalities can be a good, can help understand reasonableness better. And we have no proportionality. All the world but America has no proportionality. So let's discuss proportionality. And, so to the extent that the non-reasonableness will also mean non-proportional, I think it is out of questions. I agree that the court never intervened, never exercised jurisdiction to prevent the government to decide a very high political, generally political question. We have the case in which the government decided and parliament approved, you know, for Israel to retreat from Gaza. And a case was brought against it. And we said, we don't intervene. This is high policy. So in high policy, the court doesn't agree. Because we don't have the tools to evaluate its value and its weight in the balancing process. But otherwise, reasonableness is a balancing process. And every public official, including a member of parliament and including the executive branch altogether, should act in a balanced way. But I do think that if they will sit down and with the president at the president house, a way can be found out to solve this reasonable / proportional question. About the judges, there were many non-Ashkenazi judges on the Supreme Court. I would say maybe a quarter or a third. Not enough, I agree. No, not enough. Also Arab judges. We have one Arab judge on the Supreme Court. They are a quarter of our population. We should have two if it goes according to numbers. And I remember when I was the president, Begin was calling me once a month, and we didn't have an Arab judge. Please choose an Arab judge. He knew that this court has a veto power in it. So please bring it to Arab judge. And we have brought Salim Jubran, and he was a very good judge. And he retired, and now there's another judge which replaces him. And I think there should be two judges. As far as the non-Ashkenazi population, there was no attempt to discriminate, of course. This is nonsense. But it is right that we didn't find, and maybe failed in it, we didn't find non-Sephardic judges, candidates to the Supreme Court. We looked for them very, very badly. And one of the reasons is that when people came from Sephardic Jews who were here in Palestine, they had their own judges. Mani was a judge. The Mani family, there was a judge in the Supreme Court. There was in the district court. There were the Mani, the Samachtet, the Sephardic Sfarim Torim. They had the not representation. There were judges in the Supreme Court. But as far as those who came, let's say from Morocco, it took them time to go to study law, and it could take them time to become first-class lawyers, and then it takes time to become a judge in the magistrate court, and so it takes time until you go to the district court. And then it comes to the Supreme Court. And from them, we picked up the best of them. So if you see this time, there is a time problem here. How many lawyers, how many Sephardic lawyers from Morocco, Tunisia, Algeria, Iraq came to Israel as lawyers? Few. How many of them went to law school? Few of them. It takes time until they come to the Supreme Court. And now we have several judges, Sephardic judges, and there will be much, much more. And I hope we will have much, much more.
Thank you.
Thank you very much, Justice Barak. We'll get, my apologies, but we'll get the last question, and then we'll let Justice Barak conclude the session. Yonatan Bet Aharon, please ask your question.
Shalom. When I served in Tzahal, there was discussion of horaot bilti chukiyot ba'alil, commands that are inherently illegal. And I was wondering whether this really is a legal term, or whether somebody misled me many years ago. And if it is a legal term under Israeli or international law, can any of the recent violent reactions by police in Israel to the demonstration fall under such a legal term?
Yes, it is a legal term. It was a legal term, as you studied it when you were in the army. It is a legal term. Now there is this idea of a black flag that stands above something, and it can be, of course, used also now, no question about it. So, for example, we had a case in which a police officer threw a grenade, which several people were injured by it, and the argument was this is clearly an illegal, demonstrably illegal act, and therefore he should be brought to trial or whatever. Yes, no question about it.
Great. Thank you, Jonathan. Justice Barak, a lot of the participants here have been very active in demonstrations around the world, in Boston, obviously, and maybe you can say a few words for all of us here that are fighting abroad for Israeli democracy, and share those closing thoughts with us.
Well, to the extent that you support actions against the reform, like the demonstrations we have here in Israel, help us. I cannot tell you what exactly the help we need. I'm sure there is need for financial support, because those demonstrations cost a lot of money. But more important, I think, than demonstrations, than money, it's the moral support. We, the people that are fighting here, we should know that we, the people in Boston and in other parts of the world, are supporting you. We know the differences between us, and we know your problems, and we support you because we trust you that you are doing it as demonstrators, that you are doing it not just for personal reasons, and as judges that you are doing it in order to support Israel as a liberal democracy. This is what Israel should be, and we have been in a liberal democracy in spite of the occupation in the West Bank. I understand it. We have been, and we should continue this way. And this is what we are obliged to do by the creators of the State of Israel, by the Declaration of Independence. And we should be proud of being both Jewish and democratic. And we are one people. And we Jews here, we are a majority, but we should never forget that we were a minority abroad, and we should trust our minorities in the way we wanted them to trust us. I hope that all this counter-revolution, as I call it here, this counter-revolution in here will disappear, and the government could go back with its majority of 64, etc., could back to do whatever they need to do for the problems we are facing, the Iranian problem, and many other problems that Israel is facing, in which the opposition and coalition are not fighting one each other. It is another level of thinking about it. So, and I thank you for all your questions. I thank Gabi for you and your nice question. When you come next time to Israel, call me.
Will do. It was a pleasure to see you and talk to you.
Yeah.
Thank you everyone for inviting me to participate.
Thank you very much.
Sorry, my apologies, Professor Blum. I'll let you close the Zoom discussion.
I have no words of wisdom. I think Justice Barak filled us with wisdom and grace, and I'm just very grateful for the opportunity to be part of this conversation.
Same here. Thank you very much for joining us and being so gracious with your time, going over the time we planned, and we really appreciate it. And thank you all for joining us for this discussion.
Thank you. Thank you for having me.
Bye-bye.
Bye-bye. Shalom, shalom.
Shalom.